The SWIG program in Jewish Studies and Social Justice of the University of San Francisco acknowledges our presence on the unceded land of the indigenous Ohlone communities and pays our respects to these traditional caretakers and elders, past, present, and emerging. It is our intention that this acknowledgement plays a role, however infinitesimal, in a much larger process of confronting the past in order to create a not yet realized future rooted in justice. Welcome everyone to the USF SWIG program in Jewish Studies and Social Justice is first event of the fall 2022 semester. Woo! My name is Aaron Hahn Tapper. It's my honor and privilege to direct the SWIG JSSJ program. Before introducing Rabbi Camille Angel, one of my professional partners, let me tell you a little bit about USF, as well as our extraordinary Jewish Studies and Social Justice program. Founded in 1855, USF is the city of San Francisco's first university, a premier Jesuit Catholic school. In 1977, we broke ground by becoming the first Catholic institution in the world to establish a Jewish Studies program. Some 30 years later, in 2008, we became the first university of any kind, Catholic or otherwise, to have an academic program formally linking Jewish studies with social justice. And then in 2019, we added yet another first to our renowned history by forming a new position on campus, that of Rabbi in Residence. With the hiring of Rabbi Camille Shira Angel, we became the first Catholic school with a queer-identified Rabbi in Residence in the history of the planet Earth. Through the SWIG JSSJ program, we believe that education is the best long-term way to create systemic change. Whether one has the time to take a semester-long course or a mere few hours to hear from a single speaker, education is fundamental to making our world better, paramount in shining the spotlight on the margins, on oppressed communities who are mistreated merely because of their race, ethnicity, religion, gender, sexual orientation, or another social identity altogether. USF is a remarkable place. Our tagline, "Change the world from here," is the real deal. With 10,000 students, as our undergraduates hopefully know, USF is ranked by US News and World Report as the most diverse racially and ethnically in terms of race and ethnicity, the most diverse campus in the country. An educational institution where 1/3 of our undergraduates are the first in their families to attend college. We estimate that 10% of our student body identifies as Jewish, and more than 20% identify as queer. Let me very quickly tell you about 3 other JSSJ events that we're putting on this semester. During the second week in October, we will be celebrating the Jewish holiday Sukkot, during which time Jews traditionally build temporary dwellings, in part to help remind us of the transient nature of life. Many of these dwellings, including the one we build annually on campus, are built structurally to embody openness, both a literal and spiritual idea. 2 of the many events we're hosting in our Open Doors Campus Sukkah the second week in October are being held on Monday, October 10th and Thursday, October 13th. On Monday, October 10th, which is also Indigenous Peoples Day, we'll be hosting scholar David Kaufman for a talk entitled "American Jews and American Indians on Turtle Island, Between Colonialism and Justice." Drawing from his acclaimed book, The Jews Indian, Kaufman will address the exchanges between these two groups, which were numerous and diverse, at times harmonious, at other times discordant. Then on Thursday, October 13th, we will host Tatiana Lubavitsky Acosta, a self-identified queer, anarchist, Jewish, Nicaraguanese artist, poet, and sexual health educator, who is also the author of 2 collections of poetry, The Easy and La Movida. For our 4th and final event of the semester, held on November 16th, we will host scholar Mira Amiras, the creator of Malka's Notebook, a graphic novel about and love letter to the Hebrew alphabet. All 3 events will be held from 6:30 to 8. If you want to learn more about JSSJ program or these events, there's a sign-up sheet outside the door over there. Now, without further ado, please welcome Rabbi Angel to the podium, who will introduce tonight's renowned speaker. Thank you.
I'm the luckiest rabbi in the world, and I really do think that if you have a chance while you're here to take a couple classes in the Jewish Studies and Social Justice program, if not all of the classes that we offer, you will leave enriched and more literate about an amazing set of ideas. Chai Rachel Feldblum is a longtime civil rights advocate and scholar. She cares deeply about making the world a better place, contributing to the goal of tikkun olam, the fixing of the world, that she was taught to care about throughout her childhood. Chai grew up in an Orthodox Jewish family. Her father, a Holocaust survivor, was born in Lithuania and came to the US after World War II as a young man. He received a PhD in Talmudic studies from Yeshiva University and became one of his generation's leading Talmudic scholars. Chai's mother was the daughter of a Hasidic Rebbe who, defying the usual strictures of that world, went to college and earned a PhD in Jewish history from Columbia University. Chai's original life goal had been to be the first Orthodox Jewish female Talmudic scholar. But halfway through her time at Barnard College, she decided she wanted to move her attention to more modern law and text. She graduated from Barnard College in 1979, worked on Capitol Hill in Washington, D.C. for several years, graduated from Harvard Law School in 1985, clerked for Judge Frank M. Coffin on the First Circuit Court of Appeals and for Justice Harry A. Blackmun on the Supreme Court, and has continued to work in the legal and political civil rights arena for the past 40 plus years. As legislative counsel to the ACLU AIDS Project in the late 1980s, Chai played a leading role in drafting and negotiating the Americans with Disabilities Act of 1990. She played the same role on the ADA Amendments Act of 2008. Chai also led the drafting and negotiating of the Employment Non-Discrimination Act, ENDA, a bill to prohibit discrimination in employment on the basis of sexual orientation and gender identity. As a law professor at Georgetown Law School, Chai created a federal legislation clinic where she and her students helped nonprofit organizations advance their legislative social justice goals. The clinic's clients included various disability organizations and Catholic Charities USA. Chai also founded and directed Workplace Flexibility 2010, an effort designed to bring employers and employees together on policy approaches to advance workplace flexibility. Chai served as a commissioner of the Employment Opportunity Commission, the EEOC, from 2010 to 2019, where she played a significant role in establishing the rights of LGBTQ employees under existing sex discrimination laws, enhancing the employment of people with disabilities, protecting the rights of pregnant workers, and leading a proactive effort to prevent harassment in the workplace. From 2019 to 2021, Chai was a partner and director of workplace culture consulting at Morgan Lewis, where she helped employers create safe, respectful, diverse, and inclusive workplaces. She continues to consult with Morgan Lewis on selected projects. In 2021, Chai became a freelance civil rights advocate, scholar, and diversity, equity, and inclusion and accessibility consultant. Chai also currently serves as vice chair of the Ability One Commission, a federal agency devoted to the employment of people with significant disabilities. As an out lesbian and an out person with a disability, the hidden disability of anxiety disorder, Chai has sought to advance LGBTQ and disability pride wherever and wherever she can. Chai, I don't think I know anybody in the world who has made a bigger difference in terms of disability rights and LGBTQ rights. Like, there may be other people, but I don't know personally anyone in my lifetime. When I think about the synagogue I grew up in the 1960s and 70s, And I realized that nobody who lived who had a wheelchair was able to get into the synagogue that my father served as a rabbi like you. And I think about how those synagogues and temples and houses of worship, they also did so much to negate accessibility for LGBTQ people. Two areas that mattered to me in my life and in so many people that I'm responsible for. And to have you here to meet our students and lift us up, particularly at a time as unnerving in history as it is, when the rights that we've spent a lifetime working for are feeling threatened and ever vulnerable. It's so important that we strategize with you and learn from you on how to defend and protect and have civil, righteous, nuanced conversations that protect religious pluralism, something else I've learned a great deal about from reading you. So without further ado, please welcome our 2022 Human Rights Lecturer, Dr. Chai Rachel Feldblum.
Okay, so now you know a bunch about my life, what I've been doing. Well, number one, thank you, Aaron Tapper, for just everything you do in terms of this center, which is really just remarkable. Thank you, Rabbi Camille Angel, for literally everything that you do. Thanks for the intro, as well as the work, the day-to-day work that you're doing. And it's really a thanks to everyone in this room, right, who decided to come and say, this sounds interesting. What am I going to learn? And I really hope if you walk out of here with just one or two additional new thoughts, that's a success from my perspective. Okay, because how many times have you gone somewhere and you leave and you're like, really? What did I really learn? So hopefully that won't be the case here. Now, I also want to say that I have a bit of a personal connection to USF. My sister Miriam Feldblum started her academic career as a professor of political science at USF in 1991. And I started my academic career the same year, 1991, at Georgetown Law School. So here we were, both former modern Orthodox kids, now women, starting at Jesuit institutions. But here's the key thing. We both taught our first class the same day. So we talked afterwards, how did things go? And it turned out we had each had the same anxiety dream the night before, that we had forgotten to do a syllabus for the class, which of course we had done. But I'm happy to report that both of us have gone on to successful careers in academia and beyond, and we always did syllabi for our class. Okay, let me make sure, put on my timer, because I definitely want to have time for conversation and questions. So what I want to talk about here is to explore the sometimes conflict between the assertion of the rights of religious individuals and institutions to engage in the exercise of their religion and the rights of LGBTQ people to live freely, openly, and with dignity in all aspects of society. Now, I say very clearly, sometimes conflict, right? Because the important point that often gets lost in the public debate is that there is not always a conflict. Religious rights and LGBT rights are not inherently antithetical, right? I mean, a religious person might think it's totally fine to be LGBTQ. The person might be LGBTQ. Hello, Rabbi Angel. Or any number of other folks that might be in this room. And of course, many religious denominations fully accept LGBT people. From their perspective, yes, God created LGBT people, right? Wants them to live their life to the fullest. There is no issue about not welcoming LGBTQ people as religious leaders, as employees, as students, as clients. For this reason, a friend of mine some time ago, a good friend who's a lawyer, told me that whenever she's asked to debate a LGBTQ versus religious issue, you know, a TV producer, a conference organizer calls, she always asks, so who's presenting the viewpoint, the religious viewpoint? And if it's a lawyer who's doing it, she's like, fine. But if it's, as it often is, a religious person, a religious leader claiming, explaining the conflict, she's like, you'll need to find a religious person to present the LGBTQ perspective, right? That's not me. And there's no better way to just really put it out there. Religious rights, LGBTQ rights are not inherently antithetical. But we should acknowledge that sometimes a conflict can exist. Right? And that's going to be the case if the religious denomination believes and teaches that God has decreed that it is a sin for a person to engage in sex with a person of the same sex, or has said that it is a sin for a person to change the gender given to that person by God at birth. There are often no simple and easy answers when a conflict arises between these beliefs and the right of LGBTQ people to participate fully, openly, and with dignity in society. These conflicts demand an attention to nuance. Nuance. I think it is fair to say, however, that nuance has not been a hallmark of the public debate on this issue. So my goal in this lecture is to convey that nuance. I don't necessarily expect you to agree with how I come out on any particular fact situation. My goal in this lecture is simply to provide you a framework in which all of us can consider different factual situations. I'm going to start that by laying out a series of principles. I'm going to talk about different categories of conduct categories in which there can be a religious burden, and then apply it to cases involving LGBTQ folks. Okay, the principles. So I think we should start with 3 principles. These are ones that I believe our society should espouse and our laws should enforce. Principle 1, to the greatest extent possible, religious individuals should be able to hold and express their religious beliefs and engage in their religious practices without experiencing harm. Right? Principle number 1, protecting individual religious people. Principle number 2, to the greatest extent possible, religious organizations in which the religion is being practiced, church, synagogue, mosque, or in which religious beliefs are being transmitted to others in the faith, e.g. schools, or in which the organization is carrying out activities informed by their religious beliefs, like Catholic social services, should be permitted to operate in a manner consistent with their religious principles. That's principle number 2 with regard to religious organizations. Principle number 3, to the greatest extent possible, LGBTQ people should be able to participate freely, openly, and with dignity in all aspects of society. Few points about these principles. First, with regard to principle 3 concerning the rights of LGBTQ people, I do not differentiate between protecting LGBTQ people and protecting people of any particular race, national origin, gender, religion, or disability for this purpose. In fact, a useful mind experiment is often to substitute race or gender or religion for LGBTQ status when working through how to address a conflict in a particular fact situation. Second, I believe that all 3 principles are equally important. I don't believe that any of these principles inherently take precedence over the other. Now, some people don't believe all three principles are equally important, and that makes it a lot easier for them to decide how to address any conflict that may arise, right? Whichever principle or principles they think are more important becomes the default principle that wins. But for those of us who believe all three principles are important, we don't have access to that easy out of the default. We have to do case-by-case analyses. And sometimes one principle will prevail and sometimes another. And that's why I put the phrase, to the greatest extent possible, comma, in front of each of these principles. One final point. Religious individuals and religious institutions make choices about whether to and the degree to which they will integrate themselves into secular society. This is a choice that individuals and institutions make. Today, 2022, individuals and institutions realize there are laws protecting the rights of LGBTQ people in our society. This is the secular society into which they are choosing to enter. That doesn't mean there's not protection. It just becomes an important variable when you work through some particular fact situations. Okay, our three principles. Now, next part of the framework, let's set out 4 categories in which a law might burden religious exercise or might be claimed to burden a religious exercise. First, holding a religious belief. Right? A law could potentially prohibit the simple holding of a religious belief. Well, not in this country. Our federal constitution does not permit that. Beliefs are sacrosanct. The government can neither prohibit nor punish the holding of a religious belief. Indeed, in 1878, in the very first case the Supreme Court decided under the Free Exercise Clause of our Constitution, the clause that protects our free exercise of religion, the court made this point very clear. Congress had enacted an anti-polygamy statute, and some Mormons had petitioned to be exempted from that law based on their religious belief that polygamy was permissible. Supreme Court ruled against them, and the court said, quote, "While government cannot compel religious or other belief, it can require persons and institutions to comport their behavior to secular moral norms." Comport their behavior to secular moral norms. A secular moral norm is that LGBTQ people should have the right to participate fully, openly, and with dignity in society. Belief is sacrosanct. Doesn't mean people are not required to abide with secular moral norms. Okay, second category, conduct that expresses a religious belief. Okay, so we know government can't prohibit you from holding a religious belief, but what about prohibiting you from expressing that belief? Okay, so this is conduct in one sense, because the person is engaged in the conduct of speaking, not just believing, but it's conduct that is directly expressive. Well, expressing a religious belief is basically treated the same way as holding the belief. Government cannot prohibit you or punish you for expressing that belief. There's also the flip side. The government is not permitted to force a person to say something that is contrary to the person's religious beliefs. They cannot compel that expressive conduct. So, for example, the Supreme Court ruled that the government cannot require a declaration of belief in God as a condition of holding public office. Right? Forcing the expression of that belief was not justified. Third category, real conduct. not just expressive conduct. Conduct that is required by or prohibited by a religion. Okay? So, Supreme Court has acknowledged that not permitting a religious person to engage in conduct required by that person's religion, or forcing a person to engage in conduct that is prohibited by that religion, will place a burden on that person's free exercise of religion and needs to be justified. Right? Clearly, an explication of principle number one. The justification then becomes fact-specific. Now, up until 30 years ago, the standard was that the government had to show that the law that placed the burden was justified as, quote, narrowly tailored to a compelling government interest. Narrowly tailored to a compelling government interest. And what that meant as a practical matter was that the government had to prove that the law was enacted to meet a compelling interest, and that the only way to achieve this interest was not to allow exemptions to the law of the kind that was being asked for. This was called the compelling government interest test. Now, as you can imagine, sometimes a religious claim about conduct prevailed and sometimes not, right? It sort of depended on the conduct. Like this Amish employer who did not want to pay Social Security taxes for his employees because he felt the Amish religious belief was that the community should take care of the elderly and not the government, was told, I'm sorry. This is a law passed for a compelling interest, and you need to participate, right? And tens and tens of cases, right? Sometimes the religious claim wins, sometimes not. Now, about 30 years ago, the Supreme Court changed this standard in one respect. They kept this standard for a law that was going to be directed at religion and some, targeted religion. Then you had to have this justification. And they also kept the standard if there was a law that had lots of exemptions for people but then didn't exempt a religious group or person. So that also had to meet this compelling government interest test. But Justice Scalia, in an opinion written for the court, it's 1990, ruled that if a law was neutral and generally applicable, right, not specifically targeted to religion, if that happened to also burden a religious belief exercise, the government just needed to justify that as rationally related to a legitimate government interest. It's a very low standard, very easy for the government to meet. Now, here were the facts of that case that resulted in this ruling. And for any of you who will read in this area and they'll talk about the religious, one part of the religious community wants to overturn Smith, this is the case they're talking about. I, for a very long time, by the way, thought that Justice Scalia was completely wrong in this case, wrongly decided, thought it should be overturned. I now no longer believe it should be overturned. Actually, some of this was just even preparing this lecture and going back to things I've written and thought about. I actually think he had it right. Now, of course, I feel this just about a year or so before the Supreme Court is probably going to overturn this case. And you will see why. But here's number one, the facts of this case. Right? It's called Employment Division versus Smith. Two employees of a drug rehabilitation organization had ingested peyote at a ceremony of the Native American church. Peyote was an illegal drug under state law. The two employees were fired. They went to collect unemployment compensation. The employer contested that, saying you don't get unemployment compensation if you've been fired for cause, and you've been fired for cause for violating this law. And they sued, saying that's burdening our free exercise of religion. This conduct is required by our religion, ingesting peyote. The courts below agreed with those employees. It seems straightforward to them, partly because the Supreme Court had previously held that a state couldn't deny unemployment compensation to an employee who was fired from a job because that person would not work on their Shabbos, their Sabbath. It seemed to be the same. The Supreme Court, in this decision by Justice Scalia, disagreed. Starting, by the way, noting that there was nothing about this claim that was expressive, right? This was conduct. And Justice Scalia said, the free exercise clause does not require the government to justify a neutral, generally applicable law, like certain drugs are illegal, under a compelling government interest test. And, here's how he put it, the government's ability to enforce generally applicable prohibitions of socially harmful conduct cannot depend on how that aligns with the individual's religious beliefs. And here's another way he said it even stronger. To make an individual's obligation to obey such a law contingent upon the law's coincidence with his religious beliefs, except where the state's interest is compelling, permitting him, by virtue of his beliefs, to become, quote, a law unto himself, contradicts both constitutional tradition and common sense. Now, I don't think it really contradicted constitutional tradition. I mean, this was really changing the standard. But I think he had something about the fact that if that's what you were going to require every time some law that prohibited some conduct because of a secular moral norm could be contested, that could run into problems. That was the concept of it. And then Justice Scalia's final point was just because something is not protected by the federal Constitution doesn't mean that the states and federal governments can't choose to protect that particular value in a specific law. So, for example, as the court pointed out, a number of states have made an exemption for sacramental peyote use in their drug laws, which is what I always say about disability. Like, when you pass a law, think about how is this going to affect people with disabilities? Like, think ahead about who's in your society and see about whether an exemption, a modification might make sense. But it's much more nuanced if you do it that way. And so I now think that's probably the better way to go about this. Well, just to let you know, what happened instead was that legislatures chose to recreate the broader standard. So Congress passed the Religious Freedom Restoration Act, restored the compelling government interest standard that applies just to federal programs. A number of states passed their own religious freedom protection laws, so that'll apply to state laws. And so whenever you hear about a case in which someone is raising a religious burden claim and they win because of this compelling interest test, it's because they have access to one of those statutes. But the reason there's a push to overturn Smith by some segments of the religious community is they would like to see that protection all the time, not just when one of these statutes is available to them. Okay, fourth, final category of potential burden. This is what I call conduct that results in perceived complicity or perceived endorsement. So this claim of burden is a step removed from a claim that complying with the law will directly conflict with the religious requirement. Right? The claim instead is that complying with the law will make the religious person complicit in some way with sin, even though complying with the law itself is not directly prohibited by the religion. Okay, so that's a perceived complicity claim. And a related version of this claim is that complying with a law may make others think that the entity complying with the law is necessarily endorsing the viewpoint embodied in the law, and that viewpoint is inconsistent with their religious belief. Okay. In these latter claims, there will also often be a free exercise of speech claim, and that claim, by the way, continues to get this compelling government interest standard. Now, these are largely the claims that come up in the area of the sometimes conflict, so I'll dig deeper into these as I go into those examples. But just to lay it out as the fourth category of conduct. Everyone take a deep breath. Okay, taking that all in. All right, now let's move to applying these principles and categories to the sometimes conflict between religious rights, LGBTQ rights. Belief. I have no doubt the law will protect and normatively should protect any individual who wants to hold the belief that homosexual acts or changing one's gender is sinful. Beliefs are sacrosanct. Full stop. Conduct that is expressive. I also have no doubt that the law will protect and normatively should protect the expressions of belief about the sinfulness of homosexual acts or gender transition. As long as the expression of those beliefs do not result in harm to others, something we will explore in the employment context, expressive conduct of this kind should be protected. Third, conduct that is not expressive. So here are two examples where I think Principle 1, protecting the religious exercise of individuals, and Principle 2, protecting religious institutions, should prevail over Principle 3 of protecting the rights of LGBTQ people. So I want to start very clearly. Remember, sometimes those principles will prevail over the principle of rights of LGBTQ people. So here are two examples. Imagine you've got an LGBTQ person, grew up in a particular denomination, just loved the priest or the pastor or the rabbi or the imam that was in their, congregation growing up, and they really want that person to marry them to their same-sex partner. If the religious leader refuses to do so, the LGBT person is not getting equal access, full equal access, no doubt about it. But I don't believe the law should require individual clergy to act in a manner contrary to their religious beliefs by sanctifying the marriage. This is not a complicity argument, this is not an endorsement argument, this is conduct. In this case, I think Principle 1 controls over Principle 3. Or, what if an LGBTQ person really, really has a calling to be a Catholic priest or a Protestant pastor in a denomination that does not let gay people be their pastor, an Orthodox Jewish rabbi, a Muslim, an Islamic imam, right? But the act of making the LGBTQ person a religious clergy person is prohibited by the religion. That's conduct that would be prohibited. Principle 2 should control over Principle 3. Hence the point, to the greatest extent possible. Now, one of the reasons I also like to mention these 2 points is an important rule in this conversation is not to globalize and catastrophize. Okay? I learned this from a therapist, right? When I was way back diagnosed with anxiety disorder, which the way it manifested for me, I would make one mistake, just one mistake that I thought was a mistake, okay, my high standard, and then I'd be like, oh my God, then that means this, and that means this, and that means that, oh my God, and the world is falling apart. And she'd be like, Chai, don't globalize and catastrophize, okay? It's just this one thing. And in this area, there tends to be a lot of globalizing and catastrophizing. Oh my God, the baker's gonna have to bake the wedding cake for the same-sex couple. Next, rabbis will have to be performing same-sex marriages. No, that's not nuanced. Nuance is that there are different factual situations. One does not necessarily lead to the other. So now let's move to the last and what is the most complicated category. Conduct where the claim is that complying with an LGBT anti-discrimination law causes the person to feel complicit in sin or as endorsing sin. And this can arise in 3 circumstances. For individuals who are decision makers, they're owning a business, in which they're employing people or serving people. It can be religious individuals who are employees and are wanting some sort of accommodation, and it could be religious associations wanting an exemption. And it's different, the nuances are different depending on who is the person raising this claim. So let's start with the religious individual as the decision maker, right? This person feels, I think homosexual sex, gender transition is sinful. If I have to comply with the law saying I can't fire such a person or not, have to give them a service, I'm condoning that activity, and that condoning is making me complicit, right? So you see these various steps. Now I will tell you, as someone who grew up as an Orthodox Jew, I totally get that acts are very important. Doesn't matter what you necessarily believe or say, it's how you act that also makes a difference. But I am also sure that many people in religious denominations that feel that it is against God's will to have gay sex or do a gender transition absolutely do not feel complicit in sin when they're complying with the law that says they can't discriminate. They feel that they're complying with the law. They're cool with God, God is cool with them. They are not being complicit. But for purposes of this conversation, we're going to think about an individual who does feel complicit. Well, we have to decide two things. Number one, should we say that that feeling of complicity, which is pretty attenuated, should be considered as a legal matter, a burden on religious exercise, such that you trigger the need for the government to justify the burden? And if so, can that burden be justified? Now here's the other thing. This is another issue in which I have changed, because I had been very sympathetic to that view of complicity. But that's also because I didn't think it would necessarily cause that much harm. Because I thought, it's like a modicum of respect. You acknowledge that the religious person might feel this. But bottom line, it's a burden that will be justified because there's a compelling government interest in having that non-discrimination law, and this is the only way to achieve that interest. So it didn't seem like there would be any harm. It was much easier to accept that as a legal burden. But let me tell you, I don't feel confident in that anymore. Not with a lot of the courts we have, not with this Supreme Court. I don't know that they're going to consider, even if we have the compelling government interest test, which we'll have under some of these state and federal religious freedom acts. I don't know that they're going to say it's a compelling government interest to prohibit discrimination against LGBTQ people. And even if they say that it is, I don't know that they're going to say that, government can still achieve its interest by giving these exemptions. What's the big deal? So if that's what happens, that's a huge harm, and it's made me rethink whether it's legitimate as a matter of law to actually consider this a burden. I will also say, in terms of harms, these are very real harms. The things in the news are the baker and the photographer, and they can go to another baker and photographer for their wedding. No, that's a direct assault on one's dignity to be told to go somewhere else. Right? This is the good mind experiment. If a black person was marrying a white person and the owner of the bakery said, you just need to go down the street to another bakery because I don't do interracial marriages. Would we countenance that as society? No, we have a secular moral norm that says that's not okay. And in many cases, this is not just a cake. This is a job. This is a job. In one of the cases that we brought while I was at the EOC, called the Harris Funeral case, Amy Stevens, who had been a funeral director for 5 years, when she told the guy who owned the funeral homes, Thomas Ross, that she would now be coming to work as a woman, he fired her. And he said, it's a sin for people to change their gender. If I don't fire her, I'm complicit in sin. The Court of Appeals didn't buy that argument. The Court of Appeals said, hello, you can continue to hold your beliefs and have her on the job. This is not endorsement. And the court also said, and even if it was, this is narrowly tailored to compelling government interests. So that court did decide the right thing. And that case actually went to the Supreme Court. The Harris funeral case, together with the Bostock case, went to the Supreme Court, but only on the question of whether transgender people were covered under Title VII. And the court said yes, agreed with the EEOC. Transgender people were covered, gay people were covered under that sex discrimination law. But interestingly, the lawyers for Thomas Rost did not bring to the court the question of whether the appellate court was correct on the religious freedom issue. And I think that was very deliberate. They don't want the first case for the Supreme Court deciding this, an employment case where there's a real person who lost her job. And Amy Stevens never got another job. She was there for the oral argument on the case, but she died before the positive result came out. They don't want that the first case is an employment case. Much rather a wedding photographer case. But the concept is the same. You allow it in one, you allow it for the other. So I now believe that the complicity claim is too attenuated to actually be a legally cognizable burden. Final two examples. So this is about, I have religious individuals as employees is also pretty straightforward. I think, you, just like these businesses made a choice to enter the stream of commerce, that's the other thing. They're choosing to enter the stream of commerce to benefit from that. They're not working in a very insular religious community where the only people ever coming to their shop would be people of the same faith, And I have cousins who live in such communities, right? They chose to enter the general stream of commerce, right? And the same thing with employees, And so you got to play by the rules when you walk into that workplace. However, I do believe that expression for individual employees should be protected. Not expression that comes out as berating a gay coworker as sinful, or a trans coworker who's using the correct bathroom, but their own personal expression. Like if they're a member of a group that thinks marriage equality is wrong and against religion, but that person is respectful to LGBTQ people in the workplace, even if the employer finds out the person is part of that sort of expressive group, I don't think that person should be fired, right? To the extent possible, you should be protecting that expression of belief. Okay, but now really ending with the two on religious associations. This area is tough, I'll just say. If you thought the other areas were tough, this area is tough, okay? 2 reasons, 2 points. 1, religious institutions play an incredibly important role in transmitting religious beliefs and values to those in their faith. One cannot overstate the importance of protecting their ability to do so. Principle 2 is at its height in situations of this kind. Point number 2, there is a wide variety of religious institutions in this country. Not every religious institution controlled by or affiliated with a religious denomination has as its core mission either practicing the religion, church, synagogue, mosque, or passing on their religious values in an insular religious school. But they're still called a religious institution. The variety in religious institutions matter the most from my perspective in terms of analyzing these fact situations, and the most important variable is the degree to which they have decided whether to, and the extent to which, integrate themselves into secular society. That ends up being the most important variable. So to take as the example of Yeshiva University, which is the community in which I grew up, right? My father was a rabbi, a professor. He taught at YU. I went to the YU Girls High School, We went to the synagogue every Shabbos with all the YU students, right? That was the world I grew up in. And it was called Modern Orthodox, specifically to say, no, we want to engage with secular society. It's not like my Hasidic cousins who were completely not engaged. And the name itself indicated that. We're a yeshiva university. We're yeshiva, we're going to be teaching Torah and Talmud, and we're also university. So Yeshiva University is now in the news because Yeshiva University has accepted LGBTQ students and faculty, and the students now want to have a recognized Pride student group, and Yeshiva University doesn't want that to happen. And Yeshiva University lost in state court when the students challenged it. And last week, they sent a request up to Justice Sotomayor, who's responsible for the region in which they're in, asking Justice Sotomayor to block the ruling so it won't go into effect. And Justice Sotomayor granted that. Okay? Not exactly sure why, but possibly because she knows it's coming to the Supreme Court, and who knows? But I thought, for this lecture, this and Catholic Charities are the two that I'm going to end with in terms of analysis, okay? So, religious educational institutions vary, right? So, let's take an example of 3 different types of Jewish educational institutions. So there's a school called Lakewood Yeshiva in New Jersey. Okay, instead of modern Orthodox, they're stricter. They're called Haredi Orthodox. Okay? Boys go there after high school. They are all strict Orthodox Jewish men. They study only Torah and Talmud. They can actually get, I found out, a BA and an MA, but only in Talmudics. Okay, they are not getting a secular education. Now, this school is never going to have to worry about a student gay pride group asking to be recognized, because they have the right to accept only Orthodox Jews, including Orthodox Jews that follow their faith, and their faith is you can't be gay and an Orthodox Jew. So as far as they're concerned, they have no gay students. Of course, we all know they do have some gay students, but they're either repressed and certainly not out. Okay, but the key thing is the law allows Lakewood Yeshiva to stay completely insular. It doesn't matter that there's a federal law that says, don't discriminate based on sex. They can discriminate if they are hiring people of their own religion and taking in students that are good Orthodox Jews in how they define it. Now, on the opposite end of the spectrum, you've got the graduate schools that Yeshiva University has created. They have a law school, Cardozo. They have a medical school. They have a social work school. You would not know in those schools that this is controlled by a modern Orthodox university. I mean, they present themselves as secular institutions. No one is learning Torah or Talmud. Students, teachers of all faiths. Okay. It's very much like any other Georgetown Law School. It's even probably pretty similar to Georgetown University or USF, where you understand the Jewish heritage, but it's basically presented as a fantastic secular education. As compared to Yeshiva University undergraduate school. Because there, remember I said it's like yeshiva and a university. There's a lot of requirements in the curriculum for studying Torah and Talmud. They're all taught by Orthodox Jews, and they're basically rabbis. It's really, as a practical matter, only Orthodox Jews. Jewish men to the yeshiva, Jewish women, Orthodox women to the Stern, the women's college, and that's what they're expecting coming in. And they're expecting to keep Shabbos and keep kosher, and that's the school they're going to. Now, under the law, if Yeshiva University wanted to discriminate against LGBT people, they could. They could decide that we are only, as a matter of admissions, taking in Orthodox Jewish men and women who meet our standards. So right up front, they could say, that's it, that's part of our religion, and that's part of principle too. You get to discriminate if that's what's necessary for transmitting your values. But here's what happens with YU. I personally was shocked about this, but YU has decided to admit Orthodox Jews who are LGBT, despite the fact that Orthodox Jewish law prohibits engaging in homosexual acts. I can tell you that. The Bible prohibits men having sex with men. And then, of course, they never thought about women. So it was the rabbis in the Talmud that extended that to women. Which, by the way, when I told my father, my Orthodox Jewish rabbi father, that I was a lesbian, he was actually the first person I told. I was very close with him. And literally his first line was, but you know, the prohibition from the Torah is only on men. It's prohibition from the rabbi. Honey, whatever works for you. But in any event, I mean, it's not impossible for Orthodox Judaism to actually move on this issue. But they haven't at this point. They've admitted LGBTQ students. And in their frequently asked questions, which they put on their website because of this lawsuit, they said, you know, when the question was, why you welcome LGBTQ students in its undergraduate school? Their answer, absolutely. We welcome, love, and care for all our students, including our LGBTQ students. We host an LGBTQ support group. We require LGBTQ sensitivity training for our rabbis and faculty. Okay, clearly YU has never said that admitting LGBTQ students and supporting them is making them complicit in sin. It's forcing them to say something against their religious beliefs. It's only when they were asked to recognize the Pride Alliance group and give them the same access to services as any other student group that they said, oh, that crosses the line. That's going to be considered endorsement. You can't do that. This is about choices. If you're going to say, yes, I'm going to admit these students, then you cannot treat them as second-class citizens. It's not yes, but. It can be no. It can be no. But it can't be yes, but. By the way, for a great example of globalizing and catastrophizing, you can look at their FAQs about everything that will be destroyed in terms of their religious identity if they had to recognize this student group. None of which I think legally is correct. Okay, my last point, and then I'm over my time here, but I'm going to do my last 5 minutes of this because how can I not talk about Catholic Charities if I'm here at USF, right? Plus, I represented Catholic Charities for 20 years, as you heard, and Catholic social teaching and the work Catholic Charities has done for poor people in this country is amazing, amazing, wonderful. I'm a big supporter of them. But they have also made choices about what to engage in, right? Now, it's complex because, as I learned, a Catholic Charities in any city is directly under the control of the diocese in that city. It's not like a Catholic hospital. They are under the control of the diocese. And they're clearly also very clearly driven by the principle of Catholic social teaching. I mean, that really does permeate its provision of services. But they've chosen to offer a large array of services, serve people of all faiths, does not make being Catholic a condition of employment, and receives lots of government funds for some of their provision of services. So, for example, in terms of employment, they've made the choice of not limiting jobs to Catholics in good standing. They could do that. We only hire good Catholics. That means Catholics who do not engage in extramarital sex or gay sex, and they would be permitted to do that by the law. Okay? They haven't done that. So, for example, they hired a gay man in IT the HR person, when he came on, mistakenly told him, oh yeah, no problem for health insurance for your husband. And then a year later, somehow they find out about it and they yank the health insurance. That's not okay. It's not a yes, but, right? If you're going to say it's okay to hire that person, you can't then start drawing these lines that makes that person a second-class citizen. And similarly, although I think this is the toughest, in terms of not placing foster care kids with gay parents, there are, as I said in that very first case, right, 1878, there are secular moral values. And a secular moral value is that you treat gay people and gay couples equally. And if you've decided to go into the business of foster care placements, you should not be allowed to say, but no, not to that group. Now, I will tell you the reason why that's tough for me, as I was thinking this through, is I know that Catholic Charities is often the best entity doing this work. So I think compelling government interest, which is also the interest of the children, I don't like the idea of Catholic Charities having to get out of the business, if that's what they end up having to do. But you know what? At bottom, entities make choices. And they made the choice to enter into this secular society. I mean, mind you, this Supreme Court gave them a pass and let them do it in the Fulton case, because it just decided, oh yeah, compelling government interest standard will apply here. They did shenanigans to say that this wasn't a general law, because it had some exemptions. And then they said, yeah, compelling interest to treat, gay people fairly, but it's not narrowly tailored. You don't have to deny the exemption to these folks in order to achieve that interest. And that's what we're going to see over and over again in terms of for LGBT people. So, conclude with this. My goal in this lecture has been to convey the nuances that arise when determining how to address the situations when there is sometimes a conflict between religious exercise and LGBTQ rights. My goal was to set forth a framework that can help all of us do the case-by-case analysis, right? Articulate 3 principles: 2 protecting religious individuals and institutions, 1 protecting LGBTQ people. Think out the different categories in which a religious burden could exist or be perceived as existing, and then doing the case-by-case analysis. Sometimes the principles that reflect the secular moral norm of protecting religious exercise. I mean, I consider that a secular moral norm is to protect religious exercise will prevail, and sometimes the principle reflecting the secular moral norm of ensuring LGBTQ people can live openly, freely, and with dignity will prevail. And the choice of whether and to what extent religious individuals and institutions want to intertwine themselves with the secular world will have consequences. I appreciate the opportunity to talk with all of you and work with all of you in creating and maintaining a society that can hold both of these secular moral values and grapple and muddle through as best as we can. Thank you for your attention.
My question is, you were talking about ultra-religious institutions
Mm-hmm.
and how they can be exempt from the secular standards. Can they be exempt if they don't, can they still claim that even if they get any kind of government funding, or the students get government funding? How is that?
So this, to me, is one of the hardest questions. It's why I had it. I've thought about it. I didn't get into the lecture. And I was like, it's way too difficult. Way too difficult. But I'll just explain what the question is and why I'm stuck, right? So, take something like Lakewood Yeshiva, okay? I don't think that any of those folks necessarily get federal funding for school. But let's assume there was something that was, let's assume that Yeshiva University decided, you know what, okay, we're just gonna back off, forget about this business of supporting LGBT students, we are just gonna be way more insular. But if they're offering this secular education, their students are going to be getting federal funds with student loans. And of course, student loans benefit both the student and the institution. I really did not like the idea of taking the student loans away. And it really just, for me, went back to the principle number 2 of we want to let these religious educational institutions exist. Can they really exist if we're not going to allow their students to get loans? So part of what's so messy about this, part of what's the idea about nuance is some things will seem really clear, right? That's why I started with, oh yeah, of course you can say you can't be a rabbi, if you're gay. And other things might seem sort of unclear, like, oh, well, should that baker be able to, and it's like really, once you run it down, it's clear. You cannot start giving that allowance. And then there are other things that are really unclear and stay unclear. And that's this one. And like I said, I think places that are very insular, I don't think their students are getting student loans. I don't think they're getting federal funding to do research. But a place like Yeshiva University is. And so, I desperately hope YU does not take this all the way to the Supreme Court. They have hired as their lawyers the Beckett Fund, which is a group that's focused on trying to make impact law in this area, so I'm sure they're salivating to go to the Supreme Court. I find it sad that Yeshiva University might be the case in which the Smith case gets overturned. But I think they would not be crazy about choosing the choice of no. I don't think they want to say, we're not going to accept any LGBTQ students, because that could hurt their applicant pool. Even if they got to keep their student loans, that could hurt their applicant pool. And it almost feels like it's smarter for them to say, we're going to accept you, we'll recognize the group, but we are going to make sure that we have set out our expression that we don't think this is okay under Orthodox Jewish law. Remember, they have that right to express themselves and disassociate themselves from any endorsement. So that's why I would rather that they go. But I find it hard on balance. As of today at 7:40 on September 13th, I'm not thinking that student loans should be yanked, okay? And see how it proceeds.
I really like the way that you kind of differentiate between the beliefs and actions and endorsement. So my question
Wait, beliefs and actions and
endorsement.
endorsement, yeah.
So my question is from the sort of point of view of someone who does not want to endorse, what they think is a sinful person or act, what do you think their idea of really living a life without endorsement is? Because from this sort of understanding, it seems to be just not interacting with somebody who they perceive as sinful is in any even morally neutral way. So how do you think they would view not endorsing that?
So, to make sure I understand, are you talking about, would you say religious individual or religious institution first?
Let's see, I'll say institution.
Okay, and so the institution wants to make it clear that they do not endorse, that they believe homosexual acts are sinful, and that's why they will not accept anyone who engages in that conduct. Okay, if you're that type of school, you don't even have to do anything else in terms of saying you're not endorsing, because by not accepting those folks in, you are clearly not endorsing. The issue becomes, you've decided to let these folks in. You don't experience it as endorsement. And again, someone else, like if the law would actually force that first type of school to have to take in that person, they would consider that compelled endorsement, I'm sure. But even more, almost like more direct conduct, like you're having to, forcing to have this person in. But now this group doesn't think it's endorsement of the sin to have the student there. I think the only way that they then make it clear that they're not endorsing that is not by saying, and we're gonna treat you as a second-class citizen, and we're not gonna recognize your student group, but instead to say, we're gonna recognize your student group, and we're gonna have a sign that says, just wanna let you know, we accept these folks, we support them, but we do not endorse their actions. And in a case that was actually brought up Georgetown on a student group question, that's sort of how the court ended up. Like they said, Georgetown, you can have the student group say that the university doesn't agree with it. So I think you find your different ways. I really think that once you decide you're going to accept someone into your community, and you don't find that acceptance per se to be endorsement, I think it's pretty hard, other than just to say. That was a long answer, sorry.
I have a quick question. Did I hear you say that we LGBTQ people are protected against this workplace discrimination in every state of the country?
Yes, yes, and not only workplace discrimination. So the Supreme Court, at the same time that they took this Harris Funeral case from the EOC, they took another case called Bostock. Both of these looked at the question of whether we at the EOC were right when we said in the Title VII employment discrimination law that that law inherently already protected LGBTQ people. Right? Our argument is if you're discriminating against a gay person, by definition, that's in, you can't separate that from sex. I mean, the whole point is who they're having sex with. You know, that's a form of sex discrimination. If you discriminate against someone who's transgender, the only thing that's going on is you're discriminating because they are quote unquote changing their gender or really conforming their gender to their true gender identity. And the Supreme Court agreed, okay, and agreed in Title VII, sex discrimination means sexual orientation and gender identity. So that was employment. So there's absolutely no question. In every single workplace in this country with 15 or more employees covered by Title VII, LGBT people are covered. Every state. But not only that, sex, as Justice Alito noted in his dissent, he listed 200 federal laws that all use the word sex. Absolutely no reason that those would be considered any differently. And in fact, there have been like 30 or 40 cases, people don't talk about this, 30, 40 cases in healthcare, in housing, in education, and the courts have said, oh yeah, you're already protected under these federal laws. I've had like 2 judges that have not found that. And by the way, if and when those ever go up to the Supreme Court is going to say, we meant what we said. Okay? You're covered. Now, part of the reason why people don't necessarily know this is what I call the curious case of the Equality Act. Because you have the community saying, we need a federal law to protect us. Otherwise, we're not protected. First time I heard that, I literally thought I hadn't heard it correctly. I'm like, you gotta be kidding. We won. We're protected everywhere. Now, I'm fine about having a new federal law that adds sex and religion to the federal public accommodations law, because the federal public accommodations law is, number one, very narrow definition of public accommodations. I'd like it to be broadened to what we did in the ADA, and it doesn't include sex or religion. Now, that would be a law that would add protection. So I'm like, yeah, let's get a law that amends the public accommodations, and then has a section like a, by the way, we want to make it clear that every statute that has sex should just now say sex, parentheses, including sexual orientation and gender identity. Like, not that we need to as Congress, but we're just making very clear, so it's clear to everybody, the people, to the courts. That's not the law, that's the bill that's been introduced, and it's not how it's been described in terms of necessity. And that's sad, because I feel like, oh my God, there are LGBTQ people in Kentucky, in Tennessee, and Mississippi who think they're not protected right now. You know? I'm not going to speculate on what I call the curious case of the Equality Act, but I'm really glad you asked that question, because the bottom line is, we won. We won in the Bostock Harris renewal cases, and we should own that.
I have questions in terms of how expression comes to terms with, let's say, you mentioned a photographer who didn't want to shoot a wedding for an interracial marriage. So they choose to do that, right? They go along with that, but then they don't choose to, say, include those photos on their website. Or say that there's an employer who employs LGBTQ person and then doesn't have them eligible for promotion, let's say. So where does that line kind of get toyed in terms of, you know, it's implicit, I guess, discrimination rather than explicit?
Okay, well that's good. Number one, I would consider the second one as explicit discrimination, but that's a very interesting one on the first one, right? They don't really believe in interracial marriage, but they're in the general stream of the economy. They can't say no to the, black person who walks in. But then they get to choose what they want to put on their website as examples of their work. I would not at all feel like government should be saying, and then you have to be completely equal in terms of what pictures you put up. I don't see that as serving a particular need, right? As opposed to, it's very clear in terms of employment discrimination. You can't refuse to hire, you can't fire, and you cannot discriminate in terms and conditions of employment. And whether someone's going to get promoted, absolutely, that would fit right in.
But I just wanted to get some clarification around the point that you made about whether or not that you don't want to be yes but. So for example, the Yeshiva University, like they can't say yes, we are going to let queer students into our university, but we're not going to recognize them the same as other students by providing recognition for this queer student group, for example. So I'm kind of interested in clarification on the perspective of the difference between yes but, and no. So are you saying that no, yes, Yeshiva University is allowed to say it is not within our religious values or within our religious, expression, whatever they want to call it, to accept these queer students, that's okay, but then including them in the university, but not recognizing them as full students, that's what's not.
Right, it's a good point. I was saying this to a friend of mine, literally 2 days ago, as I was working on this, explaining it, and she said, oh, you mean it can't be yes but. And I was like, exactly. But the way you just described it just showed the need for some clarification, okay? So basically what I'm saying is that they can say no, right? They can say, you're not coming into our community because by doing that, by government forcing us to let you into our community, you're undermining our community. So I was calling that no. You could also call that saying, yes, you have the right to be exclusionary. But we keep the no, meaning you have the right to be exclusionary, even if it hurts another group, okay? And that's voluntary. They decide that that's what they want to do. They decide they want to be insular, even though it will have other negative consequences. Or they can decide that they're not going to be insular. That's the yes. They're going to decide, you know what, we care enough about the university part of Yeshiva University and presenting the second and presenting ourselves as sort of liberal. We're sort of going to ignore all those rabbis over there who might be freaking out, and we're going to give them some sensitivity training, apparently, and we're going to decide voluntarily to let LGBTQ Orthodox Jews come in. Which, by the way, I would have thought there could be LGBTQ Orthodox Jews until you see the documentary Trembling Before God. Sandy Dubowski did this, and it was fascinating because in 1995, Sandy came up to me after I gave a speech and said, I'm doing this documentary on folks who grew up in Orthodox Judaism and have left because they're gay. Would you be willing to, be interviewed? And I'm like, yeah, fine, it's totally out. Didn't hear from him for 2 years. He calls and says, you're not going to believe it. I have found gay people, gays and lesbians, who are still Orthodox. And that's what he made his documentary on. And when I watched it, it was so painful. I could not believe what these people were doing, pushing themselves into this hole because I understood it. I became not religious. I, had my reverse revelation that there wasn't a God first, and then a year later, I realized I was a lesbian. So I came in that order. These people, it's something. So anyway, if the university decides we're going to let those folks in, then, so that's the yes, the voluntary yes, then I don't think they get the chance to say yes, but only up to the line that we've decided. Like we get to decide what's endorsement. It's almost back to that. We get to decide what's endorsement. It's like no. That's going to be a legal question as to whether this somehow is endorsement that is then burned.
So I wanted to ask about, you brought up the Amish being required to pay to Social Security as part of a government interest.
Mm-hmm.
How would you compare that to religious institutions not having to pay income or property tax, especially when we have mega churches like Joel Osteen getting hundreds of millions of dollars?
Okay. Tax deduction question, yes. Tax exempt. Mm-hmm.
My question has nothing to do with that, I'm sorry to say.
Mm-hmm. It's okay.
But I was going to ask if you were worried about the overturning of Roe v. Wade and how that might end up affecting other court decisions. And if you think that'll affect other court decisions and whether they will be overturned or not. Because I know that's what a lot of people are worried about right now.
Right. Okay, those are actually two great questions to end on. It doesn't matter that they're not connected. So, there were two issues that I found very difficult. One was a student loan question asked by the person in front of you, and the other was the tax exempt question asked by you. And again, it goes back to the question of what's necessary to allow the entities to exist. And is, in fact, the tax exempt status something that is necessary? Again, it's something that benefits the institution and it benefits the donors. Now, in our the Supreme Court decided in the Bob Jones case that when the IRS chose to say to Bob Jones that was not accepting interracial couples in the student body, the IRS said, we consider that sufficient to revoke your tax exempt status. Bob Jones sued. The Supreme Court said it's within the IRS's right to decide that, and your religious claim is not good enough, right? The compelling interest of the state, of the government overrides. Personally, I wasn't quite sure as a matter of statutory interpretation that the IRS actually had that right. And I wasn't quite sure whether that was the right result. But that is the state of the law. So if the IRS decided that they wanted to revoke the tax exempt status of one of these, Lakewood Yeshiva or something else, then unless the Supreme Court decided that they're going to just treat race differently from everything else, and as I said, usually I don't think that way, but if that would be a way to limit Bob Jones to his tax, I probably would feel good about that, because I do have concerns with taking away the tax exempt status. I don't like the fact that we're supporting those institutions without tax money, because that's what it is. But on the other hand, I feel like I have these three principles and they are all of equal importance. But one could come out the other way easily. And that's my point about the framework. Framework is simply a way for you to target your thinking, even if people would come after you. So, I want them to keep their student loans, I want them to keep the taxes and status, but I find it difficult, both of those. Last one, on Roe versus Wade. I do not believe that overturning Roe in the way that they did it would ultimately overturn protection for marriage, for same-sex couples. Not because there is any intelligent legal distinction. There is not. As soon as you say there's no privacy right, because for abortion, because it didn't exist in the beginning, for the building of the Constitution, I assure you, marriage with same-sex couples was an either, right? But they don't have to be logical. If they don't want, all you need is 5 votes. So if there are 5 votes that say, well, it's different because abortion actually harms another entity and marriage doesn't harm anyone else, and somehow they use that, they can do that. And from my perspective, looking at the concurrences, I do not see passion among 5 justices. See passion among 3, certainly 2, maybe 3. I don't see a passion of 5 justices to do it. But again, I understand that concern. It's like the Marriage Equality Act that's now passed the House, in the Senate. Do I think it's really necessary? Maybe not. But do I think it's harmful? Not at all. Why not get people on the record? Why not, have that? It doesn't cause, maybe it makes people a little afraid, but it's not like the Equality Act. It's not sending a message that could actually be problematic. So, but in terms of how worried you should be about that when you go to sleep, versus lots of other things to be worried about, I put that one low. There are plenty of other things though, right?
Thank you again, Todd.